Hey guys. Hey Mitzvah. Hey Sweet Tooth. Hey Lala. Hey Caitlin. Welcome back, guys. Welcome back. This is not going to be a long video. Someone sent this to me early in the week, and I read over it today, and it's interesting. It's very interesting. Um, hey Rita. You're back, Rita. Well, anyway, it's very interesting that there is a civil case out there that has Robert's name on it. It's strange. I'm gonna bring it up to you guys' attention right now. I just want to hurry up and bring this up. The good thing is that hold on a second. Let me just bring this case up for you guys. It's so weird. Just bear with me. Just bear with me. Just a second. Just bear with me. I'm opening up the case now. Okay, I'm going to bring up the case, what it's all about, the complaint on the case. I'm showing you guys that that Robert's name is part of this case. This is like the weirdest thing. People coming all out of the woodwork on this, right? This is the weirdest. And I'm going to let this system read it for you guys. But hold on, I'm going to bring it up. Hey, Tim. Yeah, this is while during the time he's incarcerated, there's a civil case. But this one here has a long list of other people in this case. A lot of people. From Weinstein all the way down. Jay-Z's on this, a whole bunch of people. But what I want you to listen to is what is being said. And it's like the weirdest thing. It seems like people just come out the woodworks to try to file lawsuit on people that are prominent and has money. But this is the weirdest thing. Hold on, let me just bring this up for you guys. All right, hold on. And I'm gonna bring up the complaint. Okay, I'm gonna let it bring. Oh, you know what I'm talking about? Okay. All right, now look at this, y'all. Look at this. Look at this case. Look at the defendants on this case. This is crazy. All of these people on this case. Make it bigger for you guys. You see this? Make it bigger. Look how many people on this case. 1953 Trust. And you're going to go down and you're going to see Robert's name at number 23. Robert's name is on number 23. And you see Milton Brown is on there too as a defendant. You see that, right? You see also Dwayne Carter, which is Lil Wayne. See all these people in this case? This person has over 38 people in this case. You see that New York City, they have all of these people. Sony, they look like, you see Maxwell is in here too. See how this case, all of these people? Wayne Thornton, Kanye West, Beyonce, Rock Nation. You see all these people that have it. The Weinstein Corporation, Harvey Weinstein, 1953 Trust. You see this? Do you guys see this? Hey, Forensics. Yeah, you guys see it, right? You saw Robert as number 23 on this case. It's like these people coming out the woodwork. Hey, Sharon Dunbar. Sharon, don't bring up the chair. Don't bring up the chair. My hubby's here. My chair's going up in a few. See? Hey, Ronald.
Hey, Brian.
How are you?
I'm good. How are you?
Good. I have this chair. I need to be put up. So, okay, and I got the hold on, y'all. Okay, yeah, I'm back. Sorry about that. But you see this case, and it has all these people. It has 38 people in. I'm gonna let this thing read it for you guys, but pay attention to what this person is saying in this lawsuit. Just pay attention. Just listen carefully. And they have everybody that you can think of in this lawsuit. Everybody that's prominent. Okay. Hold on, y'all. Let me pull this up. And I'm going to let this thing read it for you guys. All right, here we go. You see the plaintiffs, Charlene Latham, David G. Latham, Stacy Y. Latham, plaintiff, John Doe, Jane Doe. You see these people 1 to 10, 1 to 5. You don't even know who these people are. But it's a civil class action, and it was done in August 21st, 2020, which is just last year. They submitted last year. Can you believe this? And they have all these people in it as plaintiff, as defendant. But I'm gonna let you listen to this, okay?
Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 2 of 13.
Yeah, Tim. Hold on a second. Yeah, let me see. His thing stopped. I don't know. My computer's been acting up lately. I think somebody might have hacked it because for some strange reason it's just not doing what it's supposed to do.
Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 1 of 13. Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 2 of 13. Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 3 of 13. Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 4 of 13.
I don't know what's going on here. Why
Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 5 of 13. Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 6 of 13. Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 7 of 13. Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 8 of 13. Case 1:20 CD
I don't know what's going on with this thing. I don't know what's wrong with my stuff.
Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page. Case 1 Case 1 Case 1 Case 1 Case 1
Hold on, I'm just trying to bypass it, y'all. Hold on.
Case 1 Case 1:20 Case 1:20 Case 1:20 Case 1:20 CDs Case 1:20 CD 0 Case 1:20 CD 07102 LLS Document 2 filed August 31st, 20 page 1 of 13. Case 1
Why
colon
is it
20
not
CD
reading the
0
document?
710.
Okay, yeah, we're just gonna have to read the document itself because it's playing around. All right, you ready? Because this thing is not working. Here's all the the defendants that's on this. 1953 trust defendant. 2, Harvey Weinstein defendant. 3, Sean Carter, aka Lil Wayne defendant. 4, Darren Indicate defendant. Richard Kine defendant. The Weinstein Corporation defendant. Miramax LLC, Miramax Films defendant, the Walt Disney Company defendant, Def Jam Records defendant, Rock Nation LLC defendant, Universal Music Corporation, Group defendant, Beyonce G. Knowles defendant, Kanye West defendant, Terrence Thornton defendant, Black Cube Ltd, defendant Vivad SA, defendant Wayne Carter. Again, is it the same? Okay, that's the same one. Defendant Jean-Luc Bernal, defendant Young Money Entertainment, defendant GOOD Music defendant, defendant Shelley Mastenberg Smith, defendant David Boyce, defendant Robert Kelly, defendant Milton Brown, defendant Marcel Claire, defendant Sprint Corporation, defendant Viacom CBS, defendant Virgil Obile, whatever how to say his name, defendant Quintar Investment Authority, defendant Tudor Saliba Corporation, defendant Gaylis, whatever how to say her name, Jesseline Maxwell, defendant Parkwood Entertainment, defendant New York City Police Department, defendant department, Sir Philip Green, defendant Sony Entertainment, defendant John Doe's number 1 to 100, Jane Doe's 1 to 100, defendant Corporation Doe's 1 to 100. I guess anybody that is anybody. Okay. It says the plaintiff statement of this case. Plaintiff number 1 entered this statement as a formal statement of the case against all defendant as captured in the page 1 of this statement. The Jane Doe defendant include corporation, their executive and involved personnel are fully included in this section. The Doe defendants represent employees, partner, collaborators, vendors, third parties, heirs, related entities whose identity and specific criminal roles have been initially sealed and withheld by the defendant to prevent their being brought to justice by being named in this and other civil complaint while intentionally being made unavailable to the plaintiff of this action to avoid redress. Okay, the corporation, the corporate defendant named in or identified as Doe's are accused of aiding and abetting in the felicitation of unlawful surveillance, spying, stalking, and repeated drugging, abducting, hostage taking, and kidnapping for criminal intent of sexual assault, abuse, extortion, and exploitation in the same capacity as any person named as defendant and in their capacity as corporation involved. Support to the criminal enterprise of the defendant 1 through 3 as corporate perseverers, facilitators, conspirators, and including by providing money laundering services to route payment to the parties of these large-scale criminal enterprise and criminal activity targeting the plaintiff. Number 4, some Doe's defendant identities are not revealed at the time of filing this statement to protect or preserve any criminal investigation occurring that may be jeopardized and undermined if the plaintiff reveal certain Doe defendants' identity at this stage of the proceedings. Number 5, over the course of decade, the defendant established a lucrative and psychopathic criminal enterprise where the defendant engaged in decades of human trafficking, sexual assault, and various abuse, including financial and economic exploitation, drugging for abduction, and making plaintiff number 1 and plaintiff John and Jane Doe 1 and 10 hostage. All right. It says that number 6, the defendant engaged in criminal and sociopathic conduct as a form of specific criminal intention designed as sexual harassment, extortion, physical torture, psychological torment, and revenge targeting plaintiff number 3 for her refusal to sell her child, plaintiff number 1, and children, John Doe and Jane Doe plaintiff, to the defendant 1 through 3. When the plaintiff number 3 refused to sell or allow the defendant in its capacity to sexually abuse or financially exploit plaintiff number 1 or any of her other children and grandchildren, represented as John and Jane Doe plaintiff 1 through 10. At any time, the defendant began targeting the family for economic abuses and financial exploitation, but not only consists of drugging the children of the plaintiffs 2 and 3 for sexual sex trafficking and hostage taking and related abuse, but also began exploiting the plaintiff for theft of trade secret, intellectual property, and torturous interference in the plaintiff's career and economic opportunities. Number 8, this extensive scheme of the defendant were initiated by Jeffrey Epstein, the descendant represented throughout this action by his estate in 1953 estate as revenge against plaintiff number 3. Number 9, plaintiff number 3 agreed to out-of-court multi-million-dollar monetary settlement in the late 1980s and early 1990s to avoid public criminal and civil prosecution for Epstein's sexual abuse of several of the plaintiff 2 and 3's children. Plaintiff 2 and 3 shares 6 children together. 3 sons, 3 daughters, approximately 14 grandchildren. After misappropriating Leslie Lexner money to pay the settlement, Jeffrey Epstein devised a scheme of revenge and recovering of the money by targeting the plaintiff for drugging and trafficking the children to continue to abuse at his various orgies around the world, and where he was paid large sums of elite attendees of these salacious events, and used the money from abusing the plaintiff to repay his debt to Lexner. 11. The decades of abuse and sexual assault were equally to the benefit and entertainment economic enrichment of the corporation, as well as solicited in whatever capacity by the corporation, their manager and personnel, as by the person named as defendant. Number 12, this action is in the United States Southern District Court in New York because it is where the defendant conspiracies of traffic and exploit for a criminal sexual intent targeting plaintiff number 1 occurring when she was a minor belonging to and in custody of plaintiff number 2 and 3. Number 13, over the course of 30 years since at least 1988 or 1989, the defendant did conspire to unlawfully survey, drug, and abduct for sexual assault, sex trafficking, and other exploitative abuse, exploitative abuse, plaintiff number 1 around the world, specifically around the Southern District of New York. Number 14, this action is entered into the United States Southern District Court of New York as it is one jurisdiction in which the defendant abducted plaintiff number 1 at approximately age 13 to sexually assault and exploit sexually for financial gain. Number 15, the defendants Harvey Weinstein, Sean Carter, Jeffrey Epstein, represented in this action, such as defendant number 1 in 1953's trust, conspired together and with the other defendant is to illegally transact a purchase agreement giving them ownership of plaintiff number 1, where she was a minor residing in the state of Illinois at approximately age 5 or 6, in the custody of her parents, plaintiff number 2 and number 3, with intent to committing criminal sex act against the plaintiff as a child and throughout the course of her entire adult life. Number 16, the defendant 1, 2, and 3 at no time communicated with nor received permission from plaintiffs number 2 and 3, the biological and custodial parents of plaintiff number 1, to purchase plaintiff number 1 and otherwise taking possession of her at any time as a minor child. Number 17, over the course of 30 years and longer, the defendant conspired to surveil or stalk plaintiff number 1 and number 3 in order to track the female plaintiff while the intent to commit various sexual acts against them. 18, the defendant 1, 2, and 3 conspire with the various parties and corporation named as defendant to stalk the plaintiff in order to drug, abduct, and traffic the plaintiff number 1 to various events known as sex parties hosted by the now deceased Jeffrey Epstein, represented by defendant number 1, around the world to abuse by elite, high-profile, wealthy whatever that name is, was held in all defendant number 1 properties, including in the United States and the Virgin Islands, in the intention to commit crimes against the plaintiff. Okay. Number 19, at age 13, specifically, the plaintiff number 1 was stalked in the state of Missouri, drugged and trafficked to be sexually abused at an event on 9 East 71st Street, Manhattan, 100,021 by the conspiring defendant. Number 20, at this piece of property owned by defendant number 1, plaintiff number 1 was sexually assaulted by various party attendants, specifically Harvey Weinstein and Sean Carter. 21, the defendant number 2 and 3 willfully and forcibly raped the plaintiff number 1 and committed lewd and sexual acts against upon her without consent of any plaintiff at this event held at the Manhattan property. 22, the plaintiff was repeatedly stalked, placed under unlawful surveillance, drugged, abducted, and trafficked for the sexual assault, abuse, and exploitation at regular intervals over the course of more than 20 years after the attack at Manhattan townhouse owned by defendant number 1. 23, Epstein, represented by defendant number 1, conspired with Harvey Weinstein and Sean Carter to initiate a system of stalking, surveilling, drugging, abducting, and trying to physically control, abuse, or financially extort the plaintiff number 1. 24. This conspiracy was in revenge and retaliation for settling a multi-million-dollar lawsuit out of court with plaintiff number 3, mother for Epstein criminal Epstein's crime for sexually abusing plaintiff number 1 and several of her siblings aboard the Lolita Express private jet with the currently deregistered tail name number of N908JE and on Pedophile Island. The privately owned Little St. James Island in the late 1980s and the early 1990s, after being entrusted with the unsupervised care of the children. 25. The defendant conspiracy to operate this criminal enterprise targeted the plaintiff spanned from the entire nation of the United States, where anywhere the plaintiff. Sorry, somebody just emailed me and broke my train of thought. Sorry about that. Please, guys, stop emailing me when I'm reading something. You know my mind is short. Anywhere the plaintiff traveled and resided. 26. The defendant system of stalking, drugging, and trafficking involved a complex, sophisticated criminal networks established among and in tandem with all of the defendant to traffic plaintiff number 1 for their abuse, exploitation, entertainment, and criminal intention of racketeering, exploitation, extortion, and crime and sex crime. 27. This complex network of criminal enterprise targeted the plaintiff involved. The defendant constipated. The defendant compensation of the co-conspirator defendant for their crimes of stalking, drugging, and abducting and assaulting the plaintiff number 1 at the behest of defendant number 1 through 3 through use of various business transactions, including but not limited to offering or facilitating employment contract, lucrative partnership contracts such as record deals, fashion industry ventures, and other sorted goods and services such as company perks like luxury cars, housing, real estate, gifts, and large sum of cash disguised as record advances and other legitimate business deal for decades. Number 28, the defendant engaged in intentional torturous interference, kidnapping, and holding the offspring of plaintiff number 3, specifically plaintiff number 1, hostage by routinely hiring defendant to stalk and illegally surveil the plaintiff and interact with the plaintiff number 1 under the disguise of befriending her and having romantic or business interests in any of the plaintiff so that they could use the false relationship to facilitate exportation, hostage taking, and abuse targeting the aforementioned plaintiffs. 29. This deception to commit torturous interference was done regularly to allow the defendant's ease of accessing the plaintiff's private life and space when plaintiff number 3 began violently demanding that defendant 1 through 3, defendant 1 is representative of the deceased Jeffrey Epstein, immediately cease and desist their extensive harassment, stalking, and kidnapping campaign against her and her family. 30. Plaintiff number 3 was made aware of the defendant activities by numerous witnesses who refused to participate in the criminal operation after being solicited to hire to partake in the criminal operation and receive very lucrative compensation packages, including large sums of cash and high-profile entertainment contracts, such as high visibility market and promotion opportunity. Number 31. When informed of the conspiracy targeting her and her minor children, the plaintiff, number 3, did take numerous and repeated action to demand defendants cease and desist all illegal and abusive conduct. Number 32, the defendant number 1 through 3, however, engaged in establishing a thorough network of criminal operatives to facilitate their enterprise by spying, stalking, and unlawfully surveillance and breaking and entering, torturous interference, numerous sexual assaults, sexual battery, financial exploitation, physical abuse, emotional harm, psychological torture, sexual harassment, lewd conduct, kidnapping, human trafficking, and extreme abuse for decades, specifically targeting number 1 and number three, and their offsprings, rather than cease and desist their criminal enterprise. Number 33. This criminal enterprise, orchestrated by the defendants, escalated beyond sexual assault, abuse, harassment, and emotional harm to intense and excessive financial exploitation of plaintiff number 1 through 3 and their offspring, Jane and John Doe plaintiff. 34. The defendant repeatedly abducted and hostage taken of the children of plaintiff 1 and 3, caused them emotional harm, and caused financial damage in the course of regaining possession of the children. 35. Lucrative career contract in professional sports, entertainment, and other industry were forged in exchange for or consequence of redressing the crime targeting plaintiff 2 and 3, shared 6 biological children, including but not limited to plaintiff number 1. When the plaintiff could not be used for sexual trafficking, exploitation, the defendant exploited the plaintiff's economic prowess and unique ability to pick stock, predict business marketing trend, create very lucrative trade secret, create lucrative intellectual properties, and develop very profitable business concept and consumer product to diverse array of industries. The defendant orchestrated a criminal enterprise valued at billions of dollars by the trafficking and economic exploitation of the plaintiff, for which the trade secret, theft, and related business intellectual property crimes played a significant role in the profitability of the criminal enterprise, and such crimes are being addressed in a separate action in appropriate jurisdictions. Number 38. The defendant began stalking and surveilling the plaintiff number 1 as a child to misappropriate trade secrets, intellectual properties, and other business and creative work of the plaintiff over the course of at least 3 decades, with intention of stopping despite repeatedly being demanded by the plaintiff number 1 and 3. 39. With this financial exploitation being very lucrative for the defendant, there were hundreds of millions to billions of dollars have been collected, earned worldwide by the defendant through their decades of exploiting the plaintiff's creativity and intellectual ability, while under the intense or constant surveillance of the defendant, who use audio, visual, and conspiring to befriend, date at the plaintiff 1 and 3, strictly to collect private information or trade secret and intellectual properties, in which furtherance of this criminal enterprise expanding beyond the described sex crimes. Number 40. Plaintiff number 1 is seeking civil redress in a separate complaint and jurisdiction for the extensive trade secret infringement, economic economic espionage, economic terrorism, and assorted extreme financial exploitation and abuse committed by the defendant against the plaintiff. 41. Plaintiff have only mentioned the defendant worldwide abuse and unlawful use of trade secret, intellectual property infringement, abuse of plaintiff 1 and 3, likeness, in the development and worldwide marketing of numerous high-profile singers, rappers, entertainers, and entertainment projects, including but not limited to musical album, music videos, television shows, et al. In this action to provide scope of abuse endured when the defendant were unable to drug, abduct, kidnap the plaintiff number 1 for repeated drug, sexual assault, and hold hostage for ransom by the defendant and their criminal enterprise. The action captured in the header filed in the U.S. Southern District of New York is specifically redressing the decades of sex crime targeting the plaintiff and their offspring. 43. When the plaintiff was able to prevent the drugged abduction of sexual assault against the plaintiff as a minor and as well into her adulthood, the defendants 1 through 3 responded by engaging in extreme form of harassment that conspired with the other defendant to initiate or facilitate. 44. This harassment included but not limited to sexual assault, fecicide, sexual harassment, verbally abuse, psychological torture, harassment such as gaslighting, and paying defendant to collect sexual data and other sexual explicit content featuring the plaintiff and plaintiff number 1 and 3 engage in sex act that would be classified as sexual battery in various jurisdictions on hidden cameras. 45. The harassment includes creating pedophilia, where the plaintiff number 1 and other Jane Doe plaintiff were recorded in various states of undress as minors in a secret space, and when drugged and trafficked aboard a private jet owned by defendant number 1 as well as other space for sexual assault, where defendant number 1 and other Jane Doe were being presented as child prostitute to the client of the defendant. Number 46. Plaintiff number 1 submitted this statement of the case to obtain justice to disrupt the defendant's ongoing action of to obstruct such justice while retaining and or generating profit collected from the abuse of the plaintiff as outlined above and throughout the detailed formal complaint pending submission into the case record by deceiving all parties. 47. Defendant attempted at hiding all involvement of defendant's sophisticated scheme of operating a criminal enterprise of human trafficking and trade secret theft has been ongoing for more than 30 years, and the ongoing criminal conduct indicates the defendant's spirited refusal to stop the conduct and their interest in continuing to enjoy the lavish profit from the criminal enterprise that they reported to the public and government as legitimate income, business operation, and financial and economic gains. Number 48, plaintiff reserved the right to transfer the action or complaint to alter jurisdiction as necessary in the interest of justice and amend the action to include full, correct name and identity of any additional plaintiff, including children, grandchildren, assorted relative, associate of the plaintiff, and to add the defendant whose name identities have been withheld and made unavailable at the time of this action and is listed as Doe's defendant at the time of filing this statement. Prayer for relief. 49. For this reason, as outlined in paragraph 1 through 48, the plaintiff are demanding punitive damages in the amount of $500 million in punitive and general damages in this action submitted to the U.S. District Court of the Southern District of New York. Plaintiff demand court order permanent cease and desist restraining order be issued against all the defendants at the end, any and all defendant decades long and continuing criminal conduct as outlined in the action where the defendant had made a sociopathic decades-long scheme of human trafficking, criminal sexual assault, financial exploitation, psychological torture, harassment, sexual harassment into the criminal enterprise targeting plaintiff number 1 and 2 by alleging that defendant 1 through 3 have created purchase agreement for and are remaining ownership of plaintiff number 1 and plaintiff number 2, 3's offspring, some of whom are still minors. Plaintiff 51, plaintiff demand court ordered permanent cease and desist with restraining order issued against the defendant to be extended in including all members of the plaintiff's family, including children, grandchildren, extended family, cousins, aunts, uncle, grandparents, etc., and the plaintiff's business partners / clients, friends, and romantic partners such as spouses and unmarried lover anywhere in the world due to the defendant having shown a very specific interest in propensity for targeting with criminal intent, including but not limited to of harassment, spying, stalking, torturous interference, financial exploitation, and criminal sexual intent, and the people and businesses closely associated with the plaintiff. 52. The plaintiff demands any and all fair and equitable relief as available to award by the court to redress the damages the plaintiff sustained through the decades of trauma from the exploitation, sexual crime, children abuse, sexual assault resulting in fecal-side, sexual harassment, financial abuse, economical damages, discrimination, child sex, human trafficking for profit, numerous and repeatedly drugged sexual assault, sexual battery, torturous interference in relationship, both business and personal, unlawful surveillancing, spying, gross invasion of privacy, cross-country stalking of a minor, cross-country stalking of adult, psychological torture, repeating kidnapping, abductions, hostage taken, and emotional harm et al. Outlined in this civil action. The plaintiff sustained these damages that were caused intentionally or consequently from the numerous crimes and unlawful acts willfully committing against them by the defendant and in the defendant's recklessness and wanton disregard for the law in perpetrating a lucrative criminal operation targeting plaintiffs, despite the plaintiff's numerous and repeatedly demand for the defendants to cease and desist. Their extreme and egregious criminal misconduct since at least 1988. The defendant's extreme conduct has continued in various forms throughout the year 2020, with little to no intention of the defendant willingness to stop their criminal conduct without lawsuit and their arrest on criminal charges to totally disrupt and disband the global criminal enterprise they're erected over the 3 decades. I declare under the penalty of perjury that the statement contained in this filing in the United States District Court of the Southern District of New York are true and understand the penalty of the false statement signed in the county Dallas, state of Texas. Woo! August 20th, 2020 at 3 p.m. Charlene Y. Linton, and then to give you her information. So, guys, that is the person that filed this complaint. I know it's a lot to read, but that is what's happening. That is what happened in this. So, but here's the deal. Here's what happened, the outcome of this particular case. Let me go and give you what the judge has said to this complaint. All right, this is what the judge responded. Okay. Thank God the judge is smart. I'm going to show you what the judge's statement was in this particular case, guys. All right, let's see. The judges saw this was a bunch of shenanigans. So what they did, they decided to dismiss this crap. This is what they dismissed. Okay, this person, Charlene Y. Lathan, and her husband, and family members and the children, Jane Doe, John Doe is supposed to be their children, right? Grandchildren and all that kind of stuff. They saying that all the defendants, Weinstein, Epstein, and the corporation, and anybody who has ever been tried with any kind of sexual abuse of any minor or anyone is put in this lawsuit. And if they have any kind of affiliation with those corporations, they're put on it. And since Mr. Kelly is one of the top entertainers, they added him in it, which has nothing to do with Mr. Kelly. Nothing at all to do with him. But they did add him on there because he was charged with this charge, the charges. So this person thinks they're going to gain traction by adding him, by adding Sean Carter, by adding everybody that they could think of, even Lil Wayne and all those people in it, thinking that they could win this lawsuit. Could win this lawsuit, right? So that is what basically happened on this thing here. So this is what the judge came back, and basically they dismissed their claim. Thank God the judge is smart enough to dismiss the claim. And this is what they said. This is what the judge says about this case. And this is the judge, Louis Stanton, right? And he basically saying that order of dismissal, right? The plaintiff, Charlene Y. Lathan, a Texas resident, filed this pro se. She did this on her own, y'all. She filed this case pro se, meaning that she didn't have an attorney. She just decided to file it on her own. And I guess because, Epstein has this money that it's allocated for people who's abused and things like that. So she decided she wanted to do this lawsuit. She wanted to get a piece of the action. So, but the judge said, no, not on my watch. So, says father's pro se complaint alleging that the defendant conspired to violate her rights. Although the complaint lists other individuals as plaintiff, only Lathan signed the complaint and or submitted a request to proceed without prepayment of fees. So she filed this lawsuit and she didn't even pay to file this thing here. So she did it as she didn't. God, this is funny. That is informal prep. I don't know what that means. The court grants Latham leave to proceed, IF whatever. They granted her to not have to pay the fee, right? But dismissed the complaint. The judge dismissed the complaint, and this is the reason why. The court must dismiss an informal pepere or whatever complaint or a portion of it thereof that is frivolous or malicious, fail to state a claim of which relief may be granted, and seeking monetary relief from defendant who is immune from such relief. Then they gave the case law of what this kind of stuff. The court must dismiss the complaint when the court lacks subject matter jurisdiction. While the law mandate dismissal of these grounds, the court is obligated to construct a per se pleading literally when they give a case law on it. So they're basically saying, okay, yeah, this here is going to be dismissed, but here's the deal: you can go and file to the appeals court to get your thing, to come back for it. That's what they basically told. But let me finish reading this. Okay. A claim of frugalness when it is lack of argumentable basis. Basically, it's just like what you're saying there. What the heck are you talking about, woman? You're talking nonsense. And then they gave a case law on it too of the nonsense she's talking about, right? I mean, that means anybody could come up and file a claim against all these people for some stupidity. You see this? She's talking about for her other children and grandchildren and all this kind of stuff. And then she names all these people. She even named the police department, Weinstein, Sean Carter, Kanye, all of these people. Arkansas, look. Name all these people in this stupid frivolous lawsuit. He says the plaintiff accused the named defendant and hundreds of unidentified defendant of establishing a lucrative but sociopathic criminal enterprise and engaging of decades of human trafficking, sexual assault, and various abuse, including financial and economic exploitation, drugging, and you know what? Okay, let's talk about the end. Because look, the plaintiff seeks $500 million and restraining order. Let's go all the way to the bottom because, I guess the court was like, okay, this is all right. Here's the thing: the clerk is directed to mail a copy of the plaintiff to the plaintiff, Charlene Y. Latham, and note serve as a document. The complaint is dismissed. Why? Fraudulous. And this was done on September 18, 2021. He wasted the court's time. This woman really wasted. And then look at this. This fool's gonna do an appeals, y'all. Oh my God! Hold on. She's gonna. Oh Jesus. Okay. The court sent her the paperwork for her to do the appeal. Let me show you guys this too. Let me show y'all guys. Hold on. I mean, Yeah, this is funny. Okay, let me show y'all. Let me show y'all this. Okay, hold on. Hold on, let me show y'all. She they sent her this paperwork so she could file. Here we go. Oh God, here it is. Okay, here it is. Okay. This is what the judge sends her. All the paperwork, right? Okay, dear Liz again. I'm not gonna read all this. All right. She has 30 days to file notice of appeal, right? 30 days. She has, and this is the judgment order the judge gave. So she has 30 days to appeal it, right? And she gotta pay this. They say she gotta pay this fee. There ain't no freebie like that. She did the last one. See? It tell her no personal check. So she has to pay $505 to appeal. She already filed the first one without any money because she's saying she didn't have any money. But now, in order for her to file this appeal, she got to pay $505. Oh, God, this is so funny. This is so funny. So that's what's happening with this. This lady just filing frivolous. She's not going to pay. She's not going to pay. She's not going to pay. I don't know, Cheryl. I don't know how this woman put Robert's name involved in this, but someone sent it to me because they saw Robert's name in it. And I'm like, Robert ain't got nothing to do with it. They're just saying this. Oh, Lord Jesus. They want to be part of something. But anyway, I just wanted to share you guys with this. These people with these idiotic, everybody's always trying to get $1. And all of a sudden now they want to put Robert as part of this stuff that's going on. She wants Epstein money, but then she wants to get all these other people involved in it. Did they get any? Hi! Oh, Lady Gemini. I guess not. They didn't get any stimulus check. But anyway, I'm about to get off, guys. I'll see you guys later. I just wanted to show y'all a little bit something. Where's my forensic guy? Did he leave? Did he leave? All right, forensic guy. I'll see you guys later. I just wanted to show you guys how ignorant some folks could be. Only thing is to dismiss it. Yeah, exactly. Yeah, this is some nonsense. They're going to put everybody inside of their craziness now. But that's my little spill for the day, for the night. And you guys have a great night. Randa Baby is on. I think she's on right now. You guys go over there. Head over there to her main page, her first page, which is Randa Baby. Guys, go have a good time. I'll see you guys later. Thank you guys for bearing with me in my entertainment here. But I'll see you guys later. Good night. Good night, Kaylin. Good night. Oh, thank you, Shannon, for that 35 years old birthday greeting. Nah. You mean 45, because I'm 54. So you got 10 back. It's 45. Okay. Thank you, Caitlin. Thank you. All right. I'll see you guys tomorrow. Remember, Rhoda, I'll see you in person tomorrow. So, but everybody else, Miss Fat, stop. But anyway, guys, good night. I hope you guys have a great night. Don't forget, guys, remember the $54 on Saturday. Saturday, we're going to be going live with the party. We're going to be going live. Not the party, you guys. Be secret. It's not party. It's just people just chit-chatting. It's not a party. It's not a party. It's not a party. But anyway, guys, I see you guys later. Love you guys. Bye. I'm going to get myself out. Hold on. My outro going on now. See you later. Bye.